Wait, 22/7/2020. Office this. ठीक है ना Here is the office note. Dated date টা দেখে লিখ দেবো হ্যাঁ এটা correction হবো plus upload হবো সেটা yes.
Item 2.
Where find the note? Which I also find the note.
Please pass on the note, let us see.
And I have received a copy of my runner note.
Note this. Sample.
If required, I will find a small paper.
Mr. Panda, please come to page number 2 of your note.
Yes.
And that is last but one paragraph.
Yes.
Please read it out.
Eyewitnesses who have been examined in trial but not implicated the appellant are PW 2, 3, 4, 5, 7, 10, 11, 12, 13, 18, and 19.
No, they have not implicated any of the appellant.
No,
How many appellants are there?
there are 6 members.
Out of which somebody
One
died.
is dead.
Huh?
One is
One
dead.
is-
Out
that
of
is
7
number-
appellant, one is dead.
Number 6 is dead, I think.
Yes.
So,
For instance, your lordship.
no, are they eyewitnesses to the occurrence or they just independent witnesses?
No, some of them are injured also.
Oh, I see.
Injured in the Basti.
In the first instance.
Acha.
The first one attack comes on illegal, but the occurrence witness, there are 3 eyewitnesses, then the
They are not
Who,
occurrence.
who are the occurrence eyewitnesses?
6 and
1, 6, and 15.
1, 6, and 7. Where have you given your comments on these 3 eyewitnesses?
In my note.
Yes.
Yes, your lordship may look at page number 4. Page 3, my lord.
3, okay.
Read the last 2 lines. PW1
Sure.
Kunni Behera,
Uh,
daughter of informant and niece of the deceased Jadumani, stated that occurrence started from the street and murder took place on land of Padmalabh Sahu at a distance of 300 yards from her. Padmalabh is also an accused. Names Appellant and Niranjan acquitted along with others to have chased deceased who ran out through the back door of house of Pondani armed with a farsa, 1 holding Katari, 5 armed with a Komtop, A3 Tikon armed with Tangia, A2 with Katari, A4 with farsa, and A7 with farsa, and has not specifically stated weapon held by Niran. A4 attacked deceased on the backside of the right side shoulder by farsa. A1 attacked deceased on the right hand upper arm by Katari. A3 dealt blows to right leg of deceased by Tangi. Others attacked him with their weapons. Deceased was surrounded by all other accused. C saw the incident standing close to a mango tree 40 yards from the spot. Half hour after the incident, went to the spot, found Jadumani dead with 9 injuries, including an injury a little above the right side eyelid on right frontal bone. This is at para 6. Admits hostility as they were residing on lands leased from government. In cross-examination, she admits stating to police about the family having disputes with villagers of Kachara over lease. Some of the accused were in between the place of assault and place where she stood watching the assault. has not stated to the IO that she came out of Pandari's house and witnessed the assault standing under a mango tree. Denied to have not stated to IO as to which appellant assaulted to which part of the body of deceased and to have seen cut injury above the eyebrow. These contradictions have been proved through cross-examination of PW16. Says that when assault was going on, PW15 had confined himself in the house of Mongoli. Then Ramesh is the next
This is the statement of that PW1.
one, the girl.
Okay.
PW6 is Ramesh, who is a neighbor. He has seen the incident while returning from his field, was attempted to be assaulted by Brunda Dehuri, who has been acquitted, and who was armed with koturi, which he avoided by moving. Niranjan, who was acquitted, is armed with lathi and dealt a blow to his right scapula, causing him to sit down due to pain. Says that Vidyadhar Sahu, acquitted and identified by him in the dock, had climbed the roof of PW3, made a hole in the thatch roof, located Jadumani and his family inside, and shouted aloud that they were inside and exhorted co-accused to demolish PW3's house. Names appellants to have chased deceased armed with koturi, farsa, kunta, tangia, and lathi, overpowered and overtaken on the land of Padmanabha by appellants and brutally assaulted. Other accused whom he did not name specifically had also chased deceased behind appellants. Niranjan, who has been named by PW1 to have chased deceased with these appellants, is not named by PW6. Cross-examination. Admits police having examined him 4 to 6 days after the occurrence, had been seen by police on the date of occurrence but not examined. Admits police having come to village on the next day following incident when he had gone to hospital on police requisition, was sent to hospital by police on the date of occurrence, had seen PW15 and others when he returned from the field in the basti moving hither and thither, admits dispute between deceased and villagers of Bodosaurosari regarding lease of the land, admits that he cannot say which named accused assaulted on which part of the deceased body, and that he witnessed the incident sitting near his house at a distance of 50 to 60 feet. And the spot, Padmalava's land, is on the front side of the house of Pandari, denies suggestion of injury by Niranjan during incident and demolition of his house. Well, I'd ask your lordships to pause here and kindly look at this spot in the final.
Page number?
And the
Paper book.
page 460.
Just a minute. Dita paper book is lava. Na gote.
Dita.
हाँ
464.
64 मान second volume में 464 पुस्तक है.
Yeah, research also.
तेवढं तर.
My lords may
He has not shown where these witnesses were standing.
No.
Like the PW1 near that tree na kon gote kodi de
na
mango tree
बिल्कुल नहीं.
mango tree na spot ଅଛି.
PW6 ର evidence ଟାକୁ ହଜୁର ଦେଖ. ତା ଘରଟା ଦେଖି ସେ ଗୋଟେ ଟ୍ରାୟାଙ୍ଗଲ ଅଛି 15, 16, 17, 18, 19, 20, 21, 22. ଭିଲେଜ ରୋଡ ଅଫ ଜେମାବନ୍ତ ସାହି.
PW6 ର ନା କଣ?
ତା ନା ରମେଶ ନାୟକ.
ରମେଶ ନାୟକ ଘର କୋଉଟା?
ତା ଘରଟା ହଉଛି ଟ୍ରାୟାଙ୍ଗଲ ନମ୍ବର 21.
21 ରମେଶ ନାୟକ. ହଁ.
ସିଏ କହୁଛି ସେଇଠି ବସିକିରି ସବୁ ଇନସିଡେଣ୍ଟ ଟାକୁ ଦେଖିଛି.
ଇନସିଡେଣ୍ଟ ଟା ତ ଏଠି ହେଲା.
ଇନସିଡେଣ୍ଟ ଟା ଏଠି ଫିଲ୍ଡ ଅଫ ପଦସା.
ପଦସା ଅଛି. ରମେଶ ର ହେଲା ଏଠି 21 ଅଛି.
ଯୋଉ ଘରଟାରେ ଥିଲେ ଡିସିଜ୍ ହେରିକା ସେଇଟା ହଉଛି 1. 1 କୁ ସେ ଦୌଡ଼ିକି ଯାଇଛି ଫିଲ୍ଡ ଅଫ ପଦସା.
ପଣ୍ଡାରୀ ନାୟକ ର ଘର ଭିତରେ ପଶିଥିଲେ. ତାପରେ ସେ ଚାଳ ଇଏ ହେଲାଠୁ ସେଇଠୁ ବାହାରି ପଳେଇଲେ. ପଳେଇକିନି ଫିଲ୍ଡ କୁ ଫିଲ୍ଡରେ ଅକରେନ୍ସ ହେଲା.
ତ ଏଇ ଯଦି 21 ରେ ତା ଘର ପାଖରେ ବସିଛି ବାରିରେ ବସିଛି
6 ନମ୍ବର କହୁଛି କଣ ମୁଁ ଘର ପାଖରେ ବାରଣ୍ଡାରେ
ତା
ବସି ଦେଖିବି
ବାଡିରେ ବସିକି ଦେଖିବେ
କାହିଁ ଦେଖି
ପାରା 9 ପେଜ 400
PW6
ଆଜ୍ଞା
para 9
ଆଜ୍ଞା
the land of Padmanabh is 50
about
60
50 to 60 feet from my house. Land of Padmanabh may be at a distance of 500 to 600 yards. My land is also 500 to 600 yards. I have witnessed the entire incident about which I have deposed sitting near my.
hmm. ନା ହେଲା କଣ ରମେଶ ନାୟକ
Hey. Chief ରେ ସେଇ ଜିନିଷ କହିଛି page 397 ରେ
ହୁଁ
397 ରେ para 2 ର last but one line ଦେଖନ୍ତୁ. After the assault, I sat down on the ground due to pain. Thereafter, the accused moved towards the house of Pandit. ସେଇଟା ସେ କ୍ଲାରିଫାଇ କରିଦେଇଛି ପାରା ନାହିଁ
but there is no question
No.
directly put that the place of assault
Not
would
No.
not be visible neither to him nor to the investigating officer
right
who prepared the spot map
right
that
yes
this could have been put
yes it could
but
have
that
been.
according to Ramesh Naik, he said that he was sitting on the so and these are the houses 1, 2, 3, 4, 5, 6,
I
which blocks the view of the so.
I
So if someone sits like this, so it type of question picture ତାପରେ ପଢନ୍ତୁ ଆପଣ ଲେଖିବେ
ତାପରେ ସେତିକି କହିଲା ମୁଁ ସେଇ ଜିନିଷଟା ଇଣ୍ଡିକେଟ କରିଦେଇଛି ନୋଟ
ହୁଁ
perusal of the spot
ହୁଁ
shows PW6 house marked as 21
ହୁଁ
spot is intervened by the village road as well as the houses of Damomaji, Moguri Naik, Madono, Gunduti and Maggie Deuri. Therefore, if it is accepted that he saw the incident sitting near his house, it would have been well nigh impossible for him to be able to see what was happening. After PW15 Madhu says that seeing their house being damaged and properties being ransacked, he and deceased with their families took shelter inside Pandari Naik's house. When Vidyadhara acquitted told others that deceased was sheltering in the house of Pandari, out of fear they opened the back door and tried to escape. Was chased by A6, who is dead, A1, A4, Tikki Naik, who has been acquitted, A2, A7, A3, and A5 armed with Thenga, Bhali, Kunta, Parsa, and Paturi, while chasing deceased who ran towards paddy field of Padmanabh, where he fell down and was assaulted by the persons named by Vrundavana and A4 assaulted him by brickbats, resulting in bleeding injuries on his legs, for which he could not go to deceased's rescue, and saw the assault from the Valley of Mongolia. He gave oral report of the incident to police at midday, put his LTI PW15, neither names Niranjan or Tikki as having chased or assaulted deceased with the apparatus. Cross-examination says that he had given names of 97 persons to the IO who reduced FIR into writing. 60 to 70 persons had participated. Again said 97 had participated. Stated to have been injured by Brundavan Dehuri and A4 being assaulted by them with brickbats. Has denied the suggestion that it is not mentioned in FIR or 161 statement. There was no assault on deceased before he fell down on the land. Says that Pandari's front door was broken. Admits to have said in FIR that accused made a hole in Pandari's wall and entered it. Has not stated to police that some accused made a hole in the thatch and entered Pandari's house. And in view of the evidence of PW1 that he was in the house of the other fellow throughout inside during the occurrence, this becomes the other aspect that your lordship will take into consideration is that both PW6 and 15, they say that they were injured. The IO says that he has issued requisitions, but there is no injury report on record. PW9 is the doctor who has examined the other injured persons. He does not say to have examined these two. IOର ବି ମୁଁ ନୋଟରେ ଦେଇଦେଇଛି ଯୋଉ କଣ୍ଟ୍ରାଡିକ୍ସନ କନଫ୍ରଣ୍ଟେସନ। ये जो वो जो କହିଛି ଯୋଉ ଫାର୍ଷ୍ଟ ପାର୍ଟରେ ଯୋଉ କ୍ୱେଶ୍ଚନଟା ପଚାରିଲେ ଯୋଉ those eyewitnesses who have not implicated these persons. My learned friend says that they belong to the first part. One of the eyewitnesses my lords may see is PW7 at 40. He is the father of the deceased Joguman and also of PW. He has stated that occurrence took place in the early part of Bhadrav 3 years back at 8 a.m. Just
there is no bloodstain found inside that house of
no.
So perhaps only they were the moment they went inside
They
he
concealed
fled.
themselves.
He fled away from that place. And they are in that field occurrence. Actually, assault took place in that land of
the paddy field.
First he fell down in the paddy field, then the assault took place as per PW.
And FIR रे ମଧ୍ୟ ଯୋଉ page 42 ରେ मेंशन ହେଇଛି କୋଉ ଇଏ ମାନେ ଭିତରୁ ଘର ଭିତରୁ ପଶିଲେ ମାନେ ଯେ କଣ କଟୁରୀ ଫାର୍ସା ପନ୍ଥ ଧରି ଲାଷ୍ଟ ପେଜ ଅଫ ଦି ଏଫଆଇଆର ଏବଂ ମୋର ଭାଇ ଯଦୁମଣି ବେହେରାକୁ ବହିର ମଝିକୁ ନେଇ କଟୁରୀ ଫାର୍ସାରେ ହାଣି ମାରିଦେଲେ ହଁ ମାରି ସାରି ତାକୁ ଧାନ ବିଲରେ ଫିଙ୍ଗିଦେଲେ ଏଇମାନେ ଏଇଆ ଧରିଥିଲେ।
ତେଣୁ ସ୍ପଟ ଟା ବି differ କରୁଛି from the FIR and the evidence. The Gahira is not the field. এটা গেঞ্জা আইছি সেটা হলো দেখুন দিনা হাতের কটুরি মাধব ফারসা
But still then one name is missing perhaps. There are ছটা হଉଛି না 1 2 3 4 5 6 कहा ना
डिसीज्ड एक्यूज्ड का मिसिंग राजा देव।
अच्छा and when the investigating officer came, the body was lying in that field.
No, body was lying on the road. That is what is. PW6 on the village road.
But the eyewitness's statement is that
And immediately after the dispersal of the persons, they went
They
there.
have brought the
they brought the body to the from that. Oh, अच्छा. Just one line देखिले से जो कहउछन्ती आपण कोनोसी आई विटनेस हला आपनकर जो तीनटा आई विटनेस अछन्ती
Paragraph 7, they come to
Yeah.
page 4.
When the accused persons dispersed, our family members went out to the land of Padmala and brought my elder brother Jadumani.
But
But
by then he was already dead. His body was brought and was placed near a
coconut
tree,
close to the house of Pandit.
तो जेतबळे तमाने इन्वेस्टिगेटिंग ऑफिसर जेतबळे आछी बॉडी माने से कोकोनट पाखर थिला सेठी इन्क्वेस्ट ही
Body road. Yes, specifically से कही थी para 4 रे कही थी पेज 442
ये
आईओ PW60
आयो
PW16 होची आयो हां पेज 4
442
442 हां
para 4 the dead body of the deceased Jadumani was kept on the road of the street called Jemavantadi. So I held inquest over the dead body of the deceased there in presence of someone so prepared. Paragraph 9 after the seizure for that witness.
Yeah, so that is the middle portion, that is the village road of Jemavantu.
नहीं से जो आसल्टा तो आपण देखैछन्ती ना से जो जगह आसल्ट हला जो जगह बॉडी पड़ीथिला व्हाट इज द डिस्टेंस बिटवीन द टू
100 yards from there. तापरे पांड्री नायक
मैप रे विलेज रोड ता मझीटा सेटा होची जमावंत देई
हां
सरसाई
से पांड्री नायक घर पाखरे
प्राय यार बोली मैं आपको जा देखो अंडर नाइट घरटा होची 1
एक तारी सामना रोड ता
टू पेज अछि ता स्पॉट मैप
460
स्पॉट मैप 464 पेज that 100 yards distance.
नहीं बॉडी टा सेठू नि आइले कोठी कि ना
पांड्री घर पाखरे
पांड्री घर पाखरे
कोकोनट ट्री अछि
रोड ऊपर
ए जो स्पॉट जोठी पैडी फील्ड रे जोठी माड़ हेची सेठी आइयो विजिट करी किछि रक्त फक्त देखते
No, fine, sir. The same page is the paragraph 9 of 8. Page 443.
राइट
At 4 p.m. on 24/8/94, I seized bloodstained earth and sample earth from the paddy field of Padmanabha and in presence of witnesses prepared seizure list. Exhibit so and so. No opinion.
So, if this is the evidence, then this place of occurrence is not a disputed one because of this bloodstain, etc. The question is whether the witnesses were in a position to see it.
Now, 6 is totally eliminated in view of his own evidence. 15 and 1, because of the fact that where they were seeing is not stated,
Yes, yes, 15 stated that.
and 1 has eliminated the 15 having seen the other.
50 one
ର ସ୍କୋପ ନାହିଁ ସେ ଦେଖିଥିଲା ସେ ତା ମଙ୍ଗୁଳି ଘର ସେ ରହିଥିଲା ବୋଲି but 15 is giving a statement that no I came out to the
Mongoli like barre thai dekhi, that is the house number 3, 3 number house, 3 number घर Mongoli like barre thai dekhi. Schedule 15 stated that
it is there.
it's 435. I was assaulted by the accused Vrindavan Deuri and Gaurang Pradhan by means of
Brick bats. I sustained bleeding
I
injury.
sustained bleeding injury in my both the legs.
So I
could not
to rescue my brother.
going to rescue
I
my
got
Stuck up in the valley of Mongoli because of the assault on.
that is Mongoli like is
Padmanabha is
the
clearly visible to me from the valley of Mongoli. Land of Padmanabha is about 200 cubits from the valley of Mongoli.
So this is a positive
The problem is
statement.
that his injuries have been disbelieved. There is no
And
evidence as
Mongoli-
to his injuries.
Hmm.
Vrindavana has been acquitted, who is alleged to have assaulted him.
No, this suppose let us say this positive statement has come that I was assaulted and for which I could not go there, but I was there in the from the Mongoli Naik's party. Mongoli Naik obviously is the number. It's number se na?
Mongoli is the number 3.
Number 3. Number 3 ର ବାରି ମାନେ ପଛପଟକୁ ପଳେଇ ଆସିବ ଯୋଉଠି ବସିଲେ କ୍ଲିୟରଲି ଭିଜିବୁଲ ହବ।
ମୁଁ ସେଇଟା କହୁଛି ମୋର କହିବା କଥା ହଉଛି ଏ ୱିଟନେସ ର ଏଭିଡେନ୍ସ ହଉଛି ଯେ ତାକୁ ବୃନ୍ଦାବନ ଦେହୁରୀ ଆଉ ଗୌରାଙ୍ଗ ପ୍ରଧାନ ଆସଲ୍ଟ ଦି ଜଣ ଯାକ ଆଜ୍ଞା acquitted. No appeal preferred against that. He says that he has sustained bleeding injuries in both his legs. That was the reason he could not go to the rescue of his brother. Now, where is that material? That material also is not corroborated by evidence.
Medical evidence କିଛି accuse ହେଇନି।
PW9 doesn't say that he has examined this chap. PW15.
No, but he also did not say that he has been examined medically.
Yeah.
ମଙ୍ଗୁଳି ବି ଇଏ ତ କହୁନାହିଁ 15 ମତେ ମେଡିକାଲ ଏକ୍ସାମିନ କରାହେଲା ବୋଲି କହିଲେ।
PW16 ମୁଁ ଇସୁ କରିଥିଲି injury requisition.
ନା ରିକ୍ୱିଜିସନ ଦେଲା ଏକ୍ସାମିନ ହେଲା ବୋଲି ଇଏ କହିଲା କି PW15 ବି କହିନା କି ସେ ବି କହିନା।
ये PW6 କହିଛି examine ହେଇଛି।
ନା ନା PW15 କହିନାହିଁ ଯେ ମତେ ଏକ୍ସାମିନ କଲେ ବୋଲି ଡାକ୍ତର
ମେଡିକାଲି ଏକ୍ସାମିନ ହେଇଛି ବୋଲି
କହିନାହିଁ। ତେବେ ନା ରିପୋର୍ଟଟା ଆମେ ଦେଖିବା ତ ଏକ୍ସାମିନ ହେଇନି।
as my seniors that Vrindavan Deuri has acquitted. My lord, the charge is concerned.
14 of his evidence.
There are 2 charges.
Page 437. I told the IO while lodging FIR that I was injured by accused Gauranga and Vrindavan due to their brickbacking. I also told the police about the assault on me due to brickbacking. It is not a fact that it is not mentioned in the FIR that I was assaulted by the above named 2 persons due to brickbacking. It is not a fact that I have not so stated during my examination under what it's not a fact that I have not stated at all about the assault on me. যদিও তাকে অনায়নি that he was examined, he says that he has stated to the IO, and PW16's evidence is also material. 16 କହିଲା
ଏକ୍ସାମିନେସନ କଥା ଦି ଜଣଙ୍କର ନାହିଁ ସେଠି ନାହିଁ କୋଉଠି
examination କଥା ସିନା
Requisition
କହିଛି ମୁଁ injury ହେଇଛି ଆଉ 16 କହୁଛି PW16 para 16 ରେ I also issued another requisition on that day in favor of Madhu Behura to Begunia Hospital. This is the requisition marked exhibit page 444. Because of the theory that a person cannot be disbelieved merely because a part of his evidence is not true. Now, as a whole, your lordship is required to appreciate the evidence. Na? So, if the evidence that he was injured is not corroborated by medical evidence on record, how can it be said that? Can it be said firstly that he is a witness to the incident who is speaking the truth and is not going to the rescue of his brother is acceptable? ଓ ଭାଇଟାକୁ ଯଦି 8ଟା ଲୋକ ଆଜ୍ଞା ଆକ୍ରମଣ କରୁଛନ୍ତି ମୁଁ ମରିଯିବି ବୋଲି ମୁଁ ଦୌଡ଼ିକି ଯିବିନି? ଆଉ ମୁଁ ଦୌଡ଼ିକି ଯିବା ମୁଁ ଗଲି ନାହିଁ ଧରିକି କେହି ଲୋକ ବି କହୁନାହାନ୍ତି ଯେ ମୁଁ ପ୍ରେଜେଣ୍ଟ ଥିଲି ବୋଲି ସେଠି।
ନା ନା ଷ୍ଟକ୍ ଅପ୍ ହେଇଗଲା ବୋଲି ପ୍ରାୟ କହିଛନ୍ତି ମଙ୍ଗୁଳି ଘରେ ରହିଗଲା ବୋଲି।
ସେଇଟା ଯୋଉ କହିଦେଲା ମଙ୍ଗୁଳି ଘରେ ରହିଲା ବୋଲି କଣ ପାଇଁ ଇଞ୍ଜୁରି ହେଲା ବୋଲି?
ନା ସେଟା ଇଏ ଏକ୍ସପ୍ଲେନ୍ କଲା।
କାହିଁକି?
ସେ ଯୋଉ ଆମର ସେ PW1 ବୋଧେ କହିଛି ନା ସେ ଯୋଉ ମଙ୍ଗୁଳି ଘରେ ରହିଗଲା। My father confined himself inside the house.
And that was
the house.
inside when ଆପଣ ସେ witness କଣ କହିପାରିବ? ସେ ଯୋଉ ଜାଗାରେ ଅଛି ସେ କଣ କହିବ ଯେ ଇଏ ଭିତରେ ଥିଲା ବୋଲିକିରି? The witness himself has been examined and you have not pointed out. ଯଦି ହେଲା
this is the communal group of the person they are attacking.
It's
out of fear they are here and there.
And there are several injuries that is there.
ସେ ଘରୁ ବାହାରିକିରି କିଏ କୋଉ ଜାଗାରେ ରହିଯାଇଛି କିଏ କୋଉଠି ଅଛି nobody has seen.
ଯୋଉ ଇଞ୍ଜୁରି ଗୁଡାକ ଆଟ୍ରିବ୍ୟୁଟ ହଉଛି ଆମକୁ ସେଗୁଡା କଣ ଲାଇଫ ଥ୍ରେଟନିଂ ଇଞ୍ଜୁରିଜ?
ନାଇଁ ସେଇଟା ନୁହେଁ।
ଯୋଉ ଇଞ୍ଜୁରି ତ ସେ ଏଇ ୱିଟନେସ ର କଥା ଅନୁସାରେ ଧରିକି
ମେନ୍ ଇଞ୍ଜୁରିଟା ହଉଛି ଯୋଉ
ଆଖି ପତା
ଉପରେ ସେଇଟା ଅଦରୱାଇଜ
ସେ ପଡିଗଲା ଆଉ ଡକ୍ଟର ଆଡମିଟ କରୁଛି ଇଟ୍ସ ପସିବଲ ବାଇ ଫଲ୍।
No, doctor is saying that caused by the କଟୁରୀ।
ଓକେ
ନାଇଁ କ୍ରସ୍ ହେଇଗଲା।
ସେ ଯୋଉ ସାଇଟେସନ ଗୁଡା କଣ ଦେଇଛନ୍ତି ସେ ଯୋଉ ଇଏର ଦେଖି ଯୋଉଟା କୁହାଉଥିଲା ସେଦିନ out of only one injury in the vital part and others 32 out of 32 injuries suffered by the deceased only one had been reported 92 Supreme Court now Jayaramon and vital part of the body no further assault was shown
11th citation.
right on addition for obligation with the doctor
PW
तो ସମୁଦାୟ ଇଞ୍ଜୁରି ସଂଖ୍ୟା ହଉଛି 9 9 ରୁ ଫାଟାଲ ଇଞ୍ଜୁରିଟା ହେଲା ସେ ଯୋଉ ହେଡ୍ ଇଞ୍ଜୁରିଟା କୋଉଟା ସେଟା ହଉଛି 9 ବାକି ଯୋଉ 8ଟା ଇଞ୍ଜୁରି ଇଏ ସବୁ ରହିଲା ଫୁଟରେ ଆଉ ଲେଗ ହାତରେ
ହାତ ଗୋଡ
ରାଇଟ୍ ସୋଲ୍ଡର ନମ୍ବର 3 ହଉଛି ରାଇଟ୍ ଫୋରଆର୍ମ
ହାତ ଗୋଡ ରହିଲା ଏବଂ ସେଗୁଡାକର ଆପଣ କହୁଥିଲେ ଯେ ସାଇଜ ଗୁଡାକ ହଉଛି ବହୁତ ଛୋଟ
4 inch into half inch into half inch
2 inch into half inch
into half inch 2 inch into half inch 2 inch into half inch 4.5 inch into half inch 8 inch into half inch on the middle of the back. First injury टा होची right upper arm. Cutting the skin underlying the muscle. And खाली skin deep. Second injury सेमती skin deep. Left upper arm. After the third injury ହେଲା 2 inch below lower angle of right scapula, cutting the skin and muscle. Fourth injury ହେଲା right leg 4 inch below the right knee joint, cutting skin and muscle. Fifth injury ହେଲା anterior aspect of right leg 3 inch above the right knee joint, cutting the skin only. Sixth injury ହେଲା 3 places on right foot cut injuries, 1 inch to 3 inch long and half inch wide. Fracture of the right and second and third metacarpal bones. And the foot bones dita fracture.
ये साइटेशन टा अच्छी अपन पारे ना ये जोटा नाउडी ना कौन आदो नाडो এটা টিকে দেখছিল এই যে এটা এই যে মনুপাত্রটি খুললো
1992 supplementary 3S.
না মার্ক করে পড়ে আসো মনুপাত্র মানে দেখুন আউটরা সাইন ইন করো মনু হ্যাঁ ঠিক আছে বিটা legal search. NAD Ado JAYA State of Tamil Nadu. ठीक है अच्छा याद है रे PW37 was the doctor who conducted postmortem examination. Knee, leg, ankle, leg, so and so, leg, so and so, temporal region में गोटे इंजुरी बाकी सब थाई ये सचा 32टा इंजुरी अच्छा this is
trade union rivals.
multiple injuries and injury number 22 अच्छा 22 टा कोटा lacerated wound on the swanson, the bone deep fracture, frontal bone अच्छा 8 was the cause of death. The rest of the injuries were found to be simple in nature. Doctor further opined swanson hemorrhage swanson okay. Later who paragraph ta last paragraph na कौन से जेटा analysis टा है जी 30 come to paragraph 19.
Aye. Coming now to the question of sentence.
नहीं
para 18 दा वो SCC रू देखो
from the evidence
from the evidence as noticed above, that is para 18 of SCC,
अच्छा
it emerges that according to the prosecution case itself, the injuries were caused to the deceased Prathap Chandra not only by A2 and A3 but by the other accused also, who stand acquitted. In the face of this evidence, it cannot be postulated that the two appellants alone caused all the injuries to the deceased, and that too with the common intention to cause his death. Critical analysis of the injuries received by deceased, which have been extracted elsewhere in the judgment, goes to show that deceased had suffered 15 lacerations, 12 bruises, and 5 contusions. Injuries 1 to 11 had been caused on his legs, knees, ankles, etc., while injuries 26 to 29 were on the thigh and lower part of the abdomen. Injuries 12 to 17 and 32 had been caused on the forearm, elbow, and possibility of those injuries having been received by deceased while trying to ward off blows on the vital parts of his body cannot be ruled out. Remaining injuries were 2 bruises on the front and on the right side of the chest and 2 lacerations 2 into 1 cm near the right side of the nose and the inner end of the right eyebrow. There were 2 lacerations on the right temporal region, 1 on the right occipital region. It was only injury 22, that is laceration on the back of the left side of the frontal region, 5 into 2 cm bone deep, fissured fracture, 10 cm vertical of frontal bone extending to base with comminuted fracture of the left orbital place, found to be sufficient to cause death in the ordinary course of nature. According to the medical witness, all injuries were simple in nature except injury 22 and could not have by themselves caused death, but those injuries could have precipitated the death. Since the evidence of the prosecution unmistakably asserts that injuries had been caused to the deceased by all the 6 accused, and some injuries had been caused exclusively by A2 and A3 alternatively during the third part of the occurrence, it cannot be said with certainty that the intention of the accused was to cause death of Prathap Chandran deceased. This is more so because according to medical evidence, deceased had died due to shock and hemorrhage on account of multiple injuries, and according to the prosecution version, all 7 accused had caused injuries, not only A2 and A3. Accused party was armed according to the prosecution evidence with iron rods and pipes and not with any other lethal weapon. If the accused had intention to cause death of the deceased, they would have probably come armed with more formidable weapons. Again, looking to the nature of injuries, which except for injury 22, were only simple and no other grievous injury was even caused, it appears to us that the accused possibly wanted to chastise the deceased for his trade union activities. The seat of the injuries, as also their nature, fortifies our view. According to the prosecution itself, after Prathap Chandran had fallen down in the third part of the incident, none of the accused took advantage and caused any other injury to him. Most of the injuries already noticed were on non-vital parts of the body. From the evidence and circumstances of the case, appellants don't appear to have had the intention of causing death of the deceased or even causing such bodily injury likely to cause death. They can at best be attributed with knowledge that their act was likely to cause death or to cause such bodily injury as was likely to cause death, since a number of injuries had been caused and injury 22 was sufficient in ordinary course of nature to cause death. Since a number of injuries had been caused and injury, it is not as if A2 and A3 alone were armed with iron rods and pipes, with which the injuries were caused, and their acquitted co-accused were unarmed. Acquitted co-accused, according to prosecution, were also armed with iron rods and pipes, and so it would be hazardous to guess as to which blow was caused by which act. If common intention to cause death had been established in the case, the prosecution would not have been required to prove which was the injury was caused by which accused to sustain the conviction of the accused with the aid of section 54. But in a case like this, where 5 of the co-accused stand acquitted, and the common intention to cause death is not established beyond reasonable doubt, prosecution must establish the exact nature of injuries caused to deceased by accused, with a view to sustain conviction of that accused for inflicting that particular injury. Evidence on record doesn't lead to the conclusion that A2 and A3 alone caused all injuries to the deceased with intention to cause his death. The broad circumstances of the case impel us to hold that common intention of 2 and 3 was not to cause death of the victim. Therefore, neither can be held guilty of the offense under 302 by 34 items. Since deceased did succumb to injuries caused collectively, appellants can only be held guilty of committing culpable homicide not amounting to murder.
Yeah, live streaming. 9 injuries are there, and out of which only one is fatal injury and the others are simple injuries on the non-vital part of the body. So if you see that why they have done it, that is there that the culpable homicide will come into murder if the 4 clauses are satisfied. Firstly, secondly, third, that is in their section 300, it is there. And if it comes within any of the exceptions, then it will be either 304 part 1 or part 2. So even if it does not come within any of the exceptions, but it does not satisfy those 4 clauses, then that will be also under section 304 part 2. That is there. Suppose non-vital part of the body re assault ହେଇଛି and ଗୋଟେ injury ଟା ହେଇଛି ଯୋଉଠି cumulative effect ମଧ୍ୟ ଆସୁନି, ଗୋଟେ injury କୁ particularly attributable କରାଯାଉଛି ଯୋଉମାନଙ୍କ ହାତରେ ମାନେ dangerous weapon ଅଛି, if they are not assaulting to the vital part of the body, but somehow or other one of them gave the blow. So whether it would be said that they had intention or, and who has caused that blow, fatal blow, that is also, that is another aspect also. In those decisions, who has caused that fatal blow? Otherwise it could have been segregated that that man would be so and so and this. But it is said that injuries, number of injuries and the parts of the body selected, weapons which were there in their hands. So these are very relevant factors. So once you say that intended to cause death, clause 1 is intended to cause such bodily injury as is likely to cause death. So the persons who are assaulting on a non-vital part of the body and causing this type of injury, 1 inch to 2 inch, this type of, you cannot that they had caused the injury or knowledge that this type of body causing this injury. If at least if they would have repeated, one would have given at least 2 blows, let us say, it would have, the number would have been at least 14. 7 persons participated. It would have been 14. So at least some persons are not even, if you accept that every person has assaulted, that is your case. It's not that somebody was standing, somebody only 2 or 3 assaulted. Your case is that all the persons assaulted. So all the persons assaulted by weapons which were sharp cutting weapon and they assaulted. That is your case. So if that is the case, then we are to see, because they are the witnesses, they are the eyes and ears of the court. So if we just visualize that, yes, they are telling that all the persons participated, they were holding sharp cutting weapons, and if at least 1 blow or 2 blows they would have given, then the number would have been more. But it is just 8 or 9 case, and they are assaulting on the injuries are on the non-vital part of the body. So can that clause be sufficient to come to that it is a murder? Right? So the 4 clauses are to be satisfied. Otherwise, either you bring it within the exception, or if you are failing to bring up with the exception, the prosecution's duty is that to prove that it by the medical evidence, at least these 4 clauses are satisfied. Then that will be the culpable homicide, can only be murder. If you are not able to satisfy any of the 4 clauses, then merely because the person has died, that would not be a case under 3 to come, right? So the 4 clauses, any of the 4 clauses are to be satisfied, and it would also be satisfied that his case does not come within any of the exceptions. 5 exceptions are there. Then only he will be under 302. So there must be link between the act and the death, and more particularly the satisfaction of the court that any of the clauses have been satisfied, right? So in a case of this nature, what the Honorable Supreme Court has done, I have found out 6 to 7 decisions now, one has been given, that here 32, in many cases 20, 18 blows have been given. But one or two blows are on the vital.
Right.
All the persons, like in some cases 10, 12, they participated. So what they say that maybe their intention to give a good thrashing. So that is how they have assaulted on the non-vital. Someone, nobody knows, someone dealt one blow on the vital part of the body. So prosecution is not coming forward. Who is that someone? So that is how they say that it would not be a case under so and so. First of all, participation of all the appellants, if repeated blows not given, admittedly you cannot say that they have given any repeated blows. Otherwise the injuries would have been more. You are not excluding any persons not to have touched the deceased or not to have assaulted anyone. So your case is that all of them conjointly assaulted, right? The question is that conjointly assault, one thing, death has taken place, two, and but we are to see that what are the actual assault taken place on which part of the body, because that would be a determinative factor. So like 307 cases, intention, maybe that injury is not a criteria, but when the injury is caused on a part of the body, and that is to be seen that what part the assailant has selected. From that parts, whether it can be said that he has intended to cause death. Suppose somebody fires gunshot, it may not be cause injury, but 307 is there. But when somebody is assaulting with a stick on an non-vital part of the body, can it be said that by assaulting on the hand, he intended to cause death, by leg? And the nature of injury, it is not deep, is a skin ro ye rohuchi. Gotiye matra apankar injury rohuchi. That apart, how many years they have remained in custody?
They were in custody immediately after the occurrence, they were arrested.
No, have you calculated it?
My lord, sir.
This occurrence has taken place when? Now, how many years have passed?
Taken place, my lords, in
94.
24/8/1990.
94 means now it is 31 year.
My lord. At page 9 of my note, I have stated in the last paragraph that they were taken into custody soon after the incident. They were granted bail on 19/5/1997.
For 4 years probably they were. 3-4 years they.
And remained in custody
After conviction ମଧ୍ୟ ରହିଥିଲେ
conviction ପରେ ଆଜ୍ଞା from 19/12/97
judgment କେବେ ହେଲା?
6/3/2000
judgment ହେଲା
19/12/97
ହଁ
6/3/2000 ରେ ଏଠି appeal ରେ ବେଲ୍ ମିଳିଲା।
6/3/2000 ମାନେ 8 ହେଇଗଲାଣି ଆପଣଙ୍କର ନାଇଁ 19/3/97 ପୁରା
ନାଇଁ
19/12/97
19/12 ହେଲେ ଇଏ 6/3 ହେଲା ଇଏ ହେଲା 2.5 years। ଆଉ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ଇଏରେ
94 ଟୁ 19/5/97
94 କୋଉ ମାସ ହବ?
ଅଗଷ୍ଟ ମାସରେ ଇନସିଡେଣ୍ଟ
ଅଗଷ୍ଟ 1994। ଆଉ ଇଏ ବେଲ୍ କେତେବେଳେ କେବେ ହେଲା?
19/5/97 ରେ ବେଲ୍ ବନ୍ଦ ହେଇଛି।
19/5/97 ବେଲ୍ ହେଇଛି। ତା ମାନେ ଇଏ ପାଖାପାଖି ଆସିଲା 3 ବର୍ଷ ହଉନି ଅବଶ୍ୟ। ହଁ ଇଏ 5 ହେଇଗଲାଣି।
5 ବର୍ଷ।
2 years, 9 months, 10 months, 2 years, 9 months, 2.5, 5 years here. There must be now, all must be above 50 now.
Yes.
କାରଣ ଘଟଣାର 30 ବର୍ଷ ହେଇଗଲାଣି। ଆପଣଙ୍କର ଅପିଲ ଯେତେବେଳେ ଫାଇଲ କଲେ, ଅପିଲ ହେଲା 98 ରେ ତାଙ୍କ ଏଜ୍ ସବୁ କେତେ ଥିଲା? 36 ଥିଲା। 36 ଥିଲେ ୟାର ସବୁ 66, 62, ତା ଭିତରୁ ୟଙ୍ଗେଷ୍ଟ ହଉଛି ଏଇ ଯୋଉ 27 ବର୍ଷ ଲୋକଟା, ଆପେଲାଣ୍ଟ ନମ୍ବର 3। ବାକି 48 ବାଲାର ହେଲାଣି 78, ୟାର ହେଲାଣି 60, 6ଟା ତ ମରିଗଲା। 7ର ବୟସ କେତେ?
28।
ନୋଟିସ୍ ମାନେ
ତିନି ଆଉ ସାତ ଆଉ
ପାଖାପାଖି ସବ ସେଇ 60
ଆଜ୍ଞା।
ଧରିନେଲେଣି।
What is your argument, Mr. Naik, on this issue?
I'm submitting the one decision that is the 64 Supreme Court.
What is that?
That is the when the common group of the common intention is there, that is not related to the prove the individual aspect.
No, that is different. That is different. Here is a question as has been already discussed in threadbare. Actually, it is discussed threadbare. Here it is shown that so many persons are causing the assault. And the gravity of the offense, the result of the assault is minimal. That is in a kind superficial. That cannot be said that these assault, which are not to the vital part of the body, leaving aside injury number 9,
Right.
is not fatal. So if it is not fatal and 7 persons are assaulting, can it be said that they had intention to cause the murder? They had every intention to assault him. They chased him, assaulted him. Had the only assault been proved either by strike by any person out of the 7, or as you said, see, they had come with lethal weapons. All of them had lethal weapons with them. So none of the injuries seems to be separating any of the part of the body. There is femur, forearm, everything is there. So if the intensity of the assault would have been to see that the person
पूरा
was
fracture
die, then it would have been deep cut injuries. But these are not deep cut
जो
injuries.
मारिଛନ୍ତି जो ଜାଗାରେ ସେ ଜାଗାରେ ଟିକେ ଆଉ ଟିକେ ଭିତର ହେଲା ମାନେ ଫ୍ରାକ୍ଚର ହେଇଯିବ
Fracture
ମାନେ
ହେଇଥାନ୍ତା.
ଆପଣଙ୍କର ହାଡ ଗୁଡାକ ଫ୍ରାକ୍ଚର ହେଇଯିବ ନା ଫଟିଂ ତା ଦେହରେ।
And on the contrary, the only kind of injuries that is seen in the frontal bone,
ଗୋଟିଏ
there is no fracture, admittedly. It is not a fracture, it's a laceration one. No. So in the laceration one, these could be possible according to the medical evidence. The whatever brain matters could be, because if a thrash is more, if the impact is more, this could be possible. So why not it be said that yes, he fell down. Immediately he fell down, there was an impact, and these injuries are there. No doubt, injuries are there. But how can you say that is how we just put to you what is your argument on these only one aspect.
ଜଣଙ୍କର ଯଦି
Injury.
as my esteemed brother is pointing out ମୋ ପାଖରେ ଗୋଟେ lethal weapon ଅଛି ମୋର intention ଅଛି ଯଦି ତମକୁ
ମାରିବି
death
ବୋଲି।
କରିବାକୁ ମୁଁ ତାହେଲେ କୋଉଠି ମାରିବି ଭାଇଟାଲ ପାର୍ଟ କୁ ମାରିବି ନା ଫାଷ୍ଟ ନହେଲେ ଯଦି ବି ନନ୍ ଭାଇଟାଲ ପାର୍ଟ କୁ ମାରିବି ଏମିତି
ମାରିବି ସେ ଆଉ ବ୍ଲିଡିଂ ହେଇକି ମରିଯିବ।
ହଁ ତ ଯୋଉ ଟାଇପ ର ଇଞ୍ଜୁରି ଜଷ୍ଟ ମାନେ ଯେମିତି ବ୍ଲେଡ ରେ କାଟିଲା ଭଳିଆ ସେଇ ଟାଇପ ର ଇଞ୍ଜୁରି ହେଇଛି କଟିଂ ସ୍କିନ୍
ହେଇଛି ମାଡ ଦେଇଛନ୍ତି ଜଷ୍ଟ ବଟ୍ not with an intensity that
force ନାହିଁ
force ନାହିଁ।
ଫୋର୍ସ ନାହିଁ ଏ ଟାଇପ ର ଇଞ୍ଜୁରି କରିଛନ୍ତି ନନ୍ ଭାଇଟାଲ ପାର୍ଟ ଅଫ ଦି ବଡି ଯାହାର ଫୋର୍ସ ନାହିଁ ତେଣୁ ସେଠି ଯୋଉମାନେ ଏଇ ପ୍ରକାର ୱେପନ ଧରି ଏଇଭଳି ଜାଗାରେ ମାରିକିନି ଏଇ ପ୍ରକାର ଇଞ୍ଜୁରି କରୁଛନ୍ତି କ୍ୟାନ୍ ୟୁ ସେ that they intended to cause death, number one, or they caused such injuries which are likely to cause death. ये दीटा तो मेन जिनस रहुछि ना से जो चारटा क्लॉज भीतर है
Or there is an exaggeration with respect to the holding of arm. ताले ସେମାନେ ସେ ଆର୍ମ ଧରି ନଥିଲେ କାରଣ ସେ ଆର୍ମରେ ସେତିକି ଇଣ୍ଟେନ୍ସିଟି ନହେଲେ ଇଞ୍ଜୁରି ଏଇଟା ଆସିବ ନାହିଁ। We will also have to see the prudence. Besides the medical evidence that is there, it is apparent. ସାତ ଜଣ ମାରୁଛନ୍ତି ଜଣକୁ 5ଟା ଚୋଟ ମାରିଲେ ସେ ମରିଯିବ। ଗୋଡ ହାତ ଯାହା ବି ବ୍ଲିଡିଂ ହେଇକିରି ବି ସେ ମରିଯିବ, ମେ ନଟ୍ ବି ଟୁ ଦି ଭାଇଟାଲ ପାର୍ଟ ଅଫ ଦି ବଡି।
7 ଜଣ ନୁହେଁ 8
ତାଙ୍କର
ଜଣେ ଆକ୍ୱିଟାଲି।
and your case is not that ନାଇଁ 2 ଜଣ ମାରିଲେ ଆଉ ସବୁ ଛିଡା ହେଇଥିଲେ। ଆପଣଙ୍କ କେସ୍ ଯୋଉ 3ଟା ୱିଟନେସ୍ କର କେସ୍ ହି ହଉଛି ସମସ୍ତେ ପାର୍ଟିସିପେଟ୍
ସମସ୍ତେ
କରିଛନ୍ତି।
All have died.
Anything further or will reserve? Hard, Mr. Devashish Panda and Mr. Nayak. Mr. Panda, Souls and Mr. Nayak submitted their written notes of submission along with citations which are taken in the form. Hearing this course and judgment is given. So any other matter?
The next matter is also my file written Thursday.
Take up on Thursday.
And let my learned friend find out about his, whether the assailant is still there.
Oh, acha, no, no. Oh, he has been released on bail.
Yes.
It is of the year 1990. କେତେ ବର୍ଷ ହେଇଥିଲା କି ତାକୁ ଆପଣ ଯେତେବେଳେ ଆପିଲ ଫାଇଲ କଲେ? 25 ହେଇଥିଲା ମାନେ ସେମିତି ନୁହେଁ। But have you not found it out? ଆମେ କହିଥିଲୁ ନା ଗୋଟେ ଅର୍ଡର କରିଥିଲୁ।
No, despite of repeated reminder, the IAC is not cooperating. You have, despite of repeated reminder to the IAC concern, is not
No,
cooperating.
you get it from IG prison, DG prison. You don't expect that you will be getting it from
ଗୋଟେ
this.
ଯୋଉମାନେ ଜେଲରେ ଥିବେ ସେମାନଙ୍କୁ ଆଇଜି ପ୍ରିଜେନ୍ସରୁ ଆଣିବେ। ଯୋଉମାନେ ବେଲରେ ଅଛନ୍ତି obviously IAC କରିବ। ଯଦି ସେମାନେ ଆପଣଙ୍କୁ ରେସ୍ପନ୍ସ କରୁନାହାନ୍ତି, you ask your learned advocate general to talk to the DG of police so that he will pass। ସେ ଅର୍ଡରରେ આપણે କରିଛୁ ନା।
And is that
No,
order
no,
we have
even otherwise there is a circular of the police department itself that in these kind of things you can get it from the IG administration. But here it's a question of prison. That is how you can get it from DG
Even if
prison.
he
IG and
replied
DG.
that I do not find any address, trial court judgment address and appeal judgment, both have been closed.
No,
What
we,
happened?
in the other division bench, we have already passed that order that in all the
Including that order.
Ah.
Yeah, including that order. This is the order of standing order. of this.
2010 ନା କେତେ ବଳ ପର୍ଯ୍ୟନ୍ତ କରିଥିଲେ? 2005 ପର୍ଯ୍ୟନ୍ତ। 2005 ପର୍ଯ୍ୟନ୍ତ ଯେତିକ କ୍ରିମିନାଲ ଅପିଲ ପେଣ୍ଡିଂ ଅଛି ହାଇକୋର୍ଟରେ ନାଇଁ ଅଲରେଡି ଅର୍ଡର has been
They should have.
Most of these police
No.
stations are cooperating or giving. Some of these are.
No, we expect that
I-
probably this information
Acha.
must have come to the registry.
ଗୋଟେ ଆପଣ କାମ କରନ୍ତୁ ଯୋଉଥିରେ ଇନଫର୍ମେସନ ଆସିଗଲାଣି ଏବଂ ଯୋଉଥିରେ ଡେଥ୍ କେସ୍ ଆସିଛି ହେଲା ବହୁତ କେସ୍ ଆସିଯିବଣି ତା ଗୋଟେ ବସେଇ ସବୁ ସେଗ୍ରିଗେଟ୍ କରିଦିଅନ୍ତୁ। ସେଗ୍ରିଗେଟ୍ କରି ସେଇ କେସ୍ର ଆମକୁ ନମ୍ବର ଗୁଡାକ ଦେଇଦେଲେ ଆମେ ଉଠେଇ ଦେବୁ
ଉଠେଇଦେଲେ sir.
ହେଲା। ମ୍ୟାଟର ଏଣ୍ଡସ୍ ଦେୟାର ଆପଣ କାହା ଗୋଟେ ବସ କାରଣ ଆମେ ଦେଇଛୁ 1996 ରୁ ପେଣ୍ଡିଂ ଅଛି ଡିଭିଜନ ବେଞ୍ଚ ଅପ୍ ଟୁ 2005 ମାନେ in huge number of cases
Yes,
you
yes.
must be getting the instruction। ତେଣୁ ଯୋଉଥିରେ ଡେଥ୍ ଅଛି ସେଇ କେସ୍ ଗୁଡା ସେଗ୍ରିଗେଟ୍ କରନ୍ତୁ, give us a list so that we can list it and dispose of those matters। ହେଲା ଆଉ ଗୋଟେ ଦାୟିତ୍ୱ otherwise it is not ଆପଣ ପୁଣି କଣ ହବ କି ନା ତାକୁ ଆଣି ଫାଇଲରେ ରଖିଦେବେ ସେଠୁ ପୁଣି ସେ 5 ବର୍ଷ ପରେ ପଡୁଥିବ ତାପରେ ପୁଣି ସେତେବେଳକୁ କଣ ହେଇଥିବ ଇନଷ୍ଟ୍ରକ୍ସନ ମିସ୍ କରୁଥିବେ। ଯେହେତୁ ଗୋଟେ ଅର୍ଡର ହେଇଛି ବର୍ତ୍ତମାନ ଆସୁଥିବ ନିଶ୍ଚୟ ଆପଣଙ୍କ ପାଖକୁ ଇନଷ୍ଟ୍ରକ୍ସନ somebody should be in charge ଯୋଉଥିରେ କେବଳ ଡେଥ୍ ହେଇଛି ସେଗୁଡାକ ସେଗ୍ରିଗେଟ୍। ହଁ ଡେଥ୍ ହେଇଛି ଗୋଟେ କଥା ଆଉ ଦ୍ୱିତୀୟ କଥା ଯଦି ପ୍ରିମାଚ୍ୟୁର ରିଲିଜ ଏଇ ଦିଟା କେସ୍ କୁ ସେଗ୍ରିଗେଟ୍ କରିଦିଅନ୍ତୁ ତାର ଲିଷ୍ଟ ଦେଇ ଦିଅନ୍ତୁ with case number will list all those matters ହେଲା।
ତାହେଲେ ନେକ୍ସଟ ୱିକ୍ ଗୋଟେ ପଠେଇକି
On the 7th ରହିଲେ ହବନି। If it is kept to 7th, it cannot be probable.
12th
This
Kuram.
particular case.
12th
You get these ତାଙ୍କର ନେକ୍ସଟ ଆଇଟମଟା ଅଛି ନା କାରଣ ଏଗୁଡ଼ାକ ଅଦରୱାଇଜ ଅଯଥା ପରିଶ୍ରମ ଅଛି ମରିଯାଇଥିବୁ ଆମେ ଏଠି ଅପିଲ ଶୁଣୁଛୁ